Welcome back to another video. Today we're taking a look at a couple who has a 16-year-old daughter who doesn't want to go to dad's house, and seemingly the mother is not doing anything to facilitate making the transition easier over to dad's house, and judge is a little upset about it. Apparently no one wants mom to go to jail, but let's take a look.
Court will note the appearance of Mr. Carroll on behalf of the plaintiff, Mr. Scott on behalf of defendant. This matter is before the court on the defendant's motion to show cause in this particular matter. I guess I'll ask you, Mr. Carroll, are you opposing the motion in this matter? If so, looks like we're going to have an evidentiary hearing.
Well, Judge, what I found is they didn't disclose at all that we had recently been before the court to request a therapist for Kelsey.
Okay.
And at that time, Kelsey had already been not going to dad's house. And we entered an order that I think it was the order you entered on May 8th, Judge, that at that point we indicated if she was going to parenting time, she'd be allowed to take a cell phone. So I just thought it was rather disingenuous that they didn't bring that up. And then he's been filing individual complaints with the front of the court. So they actually set a show cause date, Judge, on July 8th anyway. But I think in the end, I thought the goal of the court and everybody was to have this young lady work with a therapist. She's 16, and we brought a motion for a therapist because she was having problems with dad's house.
Okay.
I would hope we'd wait for the therapist to get some time under their belt with Kelsey to determine what's the best direction to take.
Okay.
But Your
Mr.
Honor,
Carroll, we did refer the matter for a therapist. Why would it not be appropriate to let the therapist deal with the matter, and then we can have a hearing at that point?
Mr. Carroll or Mr. Scott?
Mr. Carroll, it's Mr. Scott's motion.
Yeah, it's my, yeah. Oh, go ahead, Sean, if you want to.
No, I think exactly, Judge. I agree. I think we should have the therapist work with Kelsey. She's 16 to find out what's going on.
Okay. Mr. Scott, why wouldn't that be appropriate?
Yeah, thank you, Your Honor. First of all, really the facts of this really aren't that disputed. There was a motion for a therapist because the young lady was not liking the rules basically at dad's house. Dad said, you know, I don't want a therapist. She doesn't need a therapist. She's just not liking what I have. You've ordered the therapist and the therapist is gone, but nobody's moved to modify this court's order at all. The parenting time needs to continue. It's a court order. The defendant has week on, week off parenting time. He's appeared each and every week to pick up the child for parenting time. That order has not been modified, nor has Mr. Carroll or his client even attempted to suggest that that order be modified. The fact that the child's getting therapy, that's great, whatever it is that they need to do, but he doesn't lose his parenting time because the 16-year-old is having therapy.
I understand.
Yeah, and so really, we have 43 days now, Your Honor. We have fees that are being incurred because this order is just being ignored. And just because a 16-year-old decides that she doesn't want to have her cell phone taken away for violations of the rules at dad's house, or because mom's encouraging her not to go, we attach to the complaint and request for an order to show cause, where mom is in fact talking to this child about, hey, do I have to go? Do I have to go? Do I have to go? And mom's saying, we're working on it. We got stuff filed before the judge, but nobody has sought to change the parenting time. So it's really, I think I attached the Porter case for this court's review, which says, you know, if we don't have the ability to enforce these parenting time orders when there isn't any significant reason why this parenting time shouldn't be being had, other than a 16-year-old saying, I don't want to go because dad's rules in essence are basically something that I don't agree with. I mean, Your Honor, she's having, apparently she's 16 years old and she's being allowed to be engaged sexually. Mom has now put her on to the pill. She's also being allowed at 16 years old to go to MSU parties from down there. Dad doesn't agree with that, and so he imposes some structure which is really good for a 16-year-old child. Not to have mom buck this. He's put rules on the phone, Your Honor, and mom says, well, I'm just going to get her a phone then so she doesn't have to listen to it. And then she's writing to her. You can see in the text message of the motion that Mr. Kennedy provided that mom's saying, hide the phone.
Okay. Well, what we're going to do is the court does want the therapy to proceed in this matter, and that'll help the court discern what the problem is in the case, I am going to, the matter with the referee, that was set for, it relates to child support, so that can proceed. What the court will do is, we want to get, from the therapist, probably, sometime in, maybe we can get a report from the therapist by August 1 in this matter, and then we could schedule the matter in before, sometime in August before school starts, and hopefully get the matter resolved. At that point, I would state in this matter, court will have the plaintiff appear in person in this matter for that evidentiary hearing. And I will let the plaintiff know, ma'am, you have a responsibility as a parent to make sure that the child, again, that the parenting time does go as ordered in this matter, and the court can, not saying I will, but the court can have you incarcerated until such time as that happens. So I want you to be aware of that, that as we proceed, that is a possible remedy, is for you to go to jail until such time as you turn the child over. So.
Well, we asked also in the motion, Your Honor, that pursuant to the Casberg versus Casberg decision, just basically what the court just said, that the mom be given an affirmative duty to ensure that the parenting time happens. If she was not wanting to go to school, Your Honor, she would take some disciplinary measures to make sure that she's going to school, taking away privileges or something like that. That's what a parent does. This child isn't being beat. This child isn't being, this child is not, I didn't interrupt you, Mr. Carroll. This child is not being hurt or anything else like that. She has a disagreement with her dad about the rules that dad's imposing, which,
Okay. Well, okay, hopefully the, again, that admonition to the plaintiff will assist her in proceeding and following the orders. And if not, then we'll have to address that at the evidentiary hearing.
And Judge, just so the court's aware too, and I know counsel may have misspoke, Mr. did not show up on at least one of the occasions. On another occasion, they were picking her up from school and she's 16 and doesn't go with stepmom. So I understand, and I have a good sense of what the court's saying. I want to hear from the therapist as well, but we adamantly disagree with a lot of dad's views in this particular thing. I think he just decides he wants to blame mom for things that are going on at his house.
Well, I understand, and we'll address that at the evidentiary hearing if we have to, but at this point, just making sure that mom does attempt to facilitate that parenting time. And I know she doesn't want to go to jail, court doesn't want to have her go to jail, but I will tell you, when parents have not attempted to facilitate that, I have put parents in jail for that. So just so you know.
No, we don't need her to go to jail.
We
We just
appreciate
need,
that.
we don't need her to go to jail, but Your Honor, I know that's a relief that's available. We just want to
Okay.
have parenting time to occur. And if it's going to be that contemptuous, then that seems to be a last resort. But there's an affirmative duty that she can encourage and provide some disciplinary measures that she's going to have to adhere to if she doesn't go.
Okay,
And that's
well,
what
I think we've addressed that. I'm not going to rehash it.
Okay,
That
Thank
will
you,
be
Judge.
what the court orders, and you're free to go. Have a good day.
Yeah, you too, Judge. Thank you.
all right, thank you, Your Honor.